So what I want to do now is bring in two wonderful guests we have in the studio to help me break this down as we keep our eyes on Nelson. As soon as things pick back up there, we'll take you there live. But I want to welcome Holly Waltman and Jesse Law. Thank you both so much for being here. You both have done criminal defense work. Holly, you do it presently. Jesse, you've done it in the past, and you're a mediator now. So I want to get your thoughts on what's going on in this courtroom where the jury's deliberating the Nelson case. They're wanting to hear that testimony read back where those words, PTSD and bipolar, were used. And the judge is saying, look, those words are so commonly spread throughout all this, you might as well just hear it all. And there's a little bit of hesitation from especially the defense side in this. Holly, your thoughts first, please.
So it's interesting because the defense here doesn't want the whole thing read back. And the argument is that it's cumulative evidence and that they've already heard it. And specifically, it's not what the question is asking for from them. Either way, it's going to be a lengthy process, and I'm sure the jury is getting weary in the back. It's almost appearing like they're going to pack their bags and head back to the hotel again tonight.
What do you think, Jesse?
Well, they've had the whole trial where these words have been bandied about, you know, bipolar, mood disorder, narcissistic syndrome, and so forth. And they are now at the death penalty phase, whether they have to decide whether to put this man to death or not. And so I'm sure that some of the jurors are taking pause to look at this information more closely and perhaps even have them reiterate back to them, say, you know, what exactly were these mental states of health that they have to explore to decide whether this individual, Mr. Nelson, who himself bizarrely testified before the jury and said, you know, put me to death. You know, they are exploring his mental state to see whether he's lucid or not, or whether he had the proper mental state at the time of the alleged murder.
I was asking my colleagues here at CourtTV the same question about what should the judge do here, because the judge certainly doesn't want this coming back on appeal, and we know this is the most serious type of a criminal case you can have when a defendant is potentially facing death for his or her crimes. So what should the judge do here? Let it all come in just out of an abundance of caution and completeness? I want to get your thoughts, Holly.
In a case that's this serious, where someone's life is literally hanging in the brinks, the judge has to do exactly what he has been asked to do by the jury. He has to empower them with the information that they've asked for, and even though that's a lengthy process that both the state and the defense, as well as everyone involved in the court, is going to be exhausted, it's what is demanded of justice in this case.
And so you say let it all come in?
Yes.
Yes.
I agree with Holly. I certainly agree, and with you as well, to err on the side of caution. Let the information come out, especially when the jurors are still deliberating, and they've specifically asked for this information regarding mental state. During the course of the trial, they brought up the information of the DSM-5, which regards mental health. But that particular information was not put into evidence, and it wasn't explored by the counsel to a certain degree. But when you start banding around these terms like bipolar disorder, schizophrenia, narcissism, and so forth, yes, someone's going to be asking questions, and I think it's best that Judge White decides to let the jury see this information.
Ladies, we appreciate your thoughts. I want to switch gears now. Let's talk about the Terrell case happening in a Metro Atlanta courtroom. This is so heartbreaking when you hear the facts that this 91-year-old dementia patient, a U.S. Air Force veteran, was allegedly beaten to death by the person responsible for caring for him. It makes you cringe. And again, I think this case serves as a great reminder of these are just allegations, because as we've heard the prosecution's case, I'm seeing doubt come up. And I was a prosecutor, and I'm seeing, and I try to look at everything as objectively as I possibly can, and that's my job here, you know, Court TV. And I want to pick your brains as lawyers who've tried cases on the defense side. What we've seen here is a lot of statements from this patient who had dementia about he hit me, all this, he hurt me, I'm in pain, whatnot. And then you're hearing consistent statements from the accused saying, this was an accident. I went to care for him, he was fighting with me. The way he fell, the way I caught him, this is how he had happened. And he consistently said the same thing to law enforcement, was cooperative, reenacting it. It's really shedding a lot of light on a whole nother way this whole incident could have occurred. I want to get your thoughts. Are you thinking the same thing and watching this case so closely that it's kind of taking a different turn? Holly.
I thought it was a very interesting way to rest the state's case, to play the reenactment. In a way, for me, it almost jump-started the defense's presentation of the evidence. And I wonder what that did for Mr. Terrell and his counsel in deciding whether or not to testify, because in a way, he kind of already has 3 times.
He got his story out there. You're right. So he really doesn't have to take the stand and tell it. They were able to tell it through the videos. And we were talking just a few minutes ago in our daily sidebar about how the defense really, I mean, they had the job done for them by the prosecution. And I keep thinking about this. Why would they have introduced that? And I keep thinking, well, because he gave this to law enforcement. Law enforcement had it. It's going to be given to the prosecutor's office. They're going to say, okay, we've got to turn this over in discovery. If we don't introduce it, the defense will. Do you think this is preemptively to introduce it because they know it would be coming in by the defense? What do you think, Jesse?
Well, I really think that the defense believed that the state's already laid out the case not only for the state, but also for the defense. And to put the defendant now on, to even risk the chance of putting the defendant on the stand, would risk the opportunity for the state to cross-examine the defendant. You cannot cross-examine an audio tape. And so why put the defendant on the stand and risk whatever opportunities he has to obtain an acquittal?
Right. I completely agree. Let's look at some testimony from the medical examiner. And we know there's going to be a big battle of 2 different forensic pathologists because that's who the defense will be presenting tomorrow morning. So let's listen to the state's expert now, and we'll talk more on the other side.
You have said "we" a number of times. Is your work part of a team?
I do. I have a group of people that I work with. I have investigators. There are other physicians in the office. At the point that a decision is made, it's the decision of the physician, but we listen very carefully to other, the people who have been helping us with the process.
And you've mentioned, I guess, different types of examination, particularly in the context of examining the body. Are there multiple phases to your examination of a body?
There are. Anytime an autopsy, an examination is performed, we have some cases where we're able to stop with just the external portion of the examination. We always start with some sort of history. We want to know some amount of information before we begin doing an invasive procedure. If you walked into your doctor's office and the first thing they did was start poking you with needles and sticking a stethoscope and never asked you why you were there, you'd probably find another doctor. Similarly, we want some amount of history before we start looking for things. We're behaving very similar to any other physician in that respect. We then will begin with an external examination, which is similar to what the doctor does in the doctor's office. We're looking for visible signs of disease, and we're looking for trauma. It gives us the opportunity to get somebody in good light, to get them undressed, to get them cleaned up, whether there's something obscuring, mud, blood, whatever may be present. At that point, if we continue, we will go on and do the internal examination, which is what most people think of as a traditional autopsy. Each organ will be examined, it'll be weighed, and we will look both for the presence of injury and the presence of natural disease. We have additional tests we may perform, much like any other physician. We do laboratory tests. We sometimes look at things under the microscope. We sometimes send tests for toxicology, or we do microbiology cultures. We have a lot of choices of things we can do. And then we have to put all of it together and present it in a cohesive fashion in a report. And the autopsy report is our final output product to show what and describe what we saw and what our opinions are.
When you are doing this external examination and the internal examination, do you do that at a particular location?
Yes, sir.
Where do you do that?
That's done at the medical examiner's office.
So you have your own office and lab where you would transport the body? Correct. Okay. So at the beginning of the process, does somebody go and retrieve the body from wherever they may have passed?
Yes.
Okay. So in this particular case, are you familiar with the death investigation and autopsy of Adam Bennett?
I am.
Okay. Did you perform that examination yourself?
I did.
Okay. And do you know when you did that?
The autopsy was done on August 18th, starting at about 10 o'clock in the morning.
Is that 2017?
I'm sorry, yes, 2017.
Okay. And is there a reason that you do the autopsy yourself, as opposed to just having somebody else do it and maybe you look at photos or something of that sort?
Well, that's not how medicine is done. You wouldn't go to a doctor who looked at a picture of you and told you what you had. You want somebody who can actually look at you. And a lot of times, you need to be able to manipulate somebody. You need to be able to look under their arms. You need to be able to roll them up and look at their back. You need to be able to put your hands and your eyes on them. Television has done a great job of convincing people that everything done in forensics is high tech. It's not. It's my eyeball and my brain that are really determining the findings here. I have tests, I have ancillary procedures, but when it comes right down to it, the practice of medicine is done with my hands and my eyes and my brain, and that's what the important part is. And so doing it via photographs or doing it via somebody else's work is impossible. You need to be able to actually see what you're doing and work from it.
And as you are doing that, do you also take photos to document?
I do.
Okay. And did you take photos to document the examination that you performed of Adam Bennett's body?
I did.
All right, I want to hone in on something important here. Did you notice how the medical doctor said this is not how medicine is done when the prosecutor asked him how important it is for him to perform the autopsy himself and not just review a report of an autopsy someone else did? So I want to turn to my guest now. What's coming tomorrow is a medical doctor will be presented by the defense who did not personally conduct that autopsy. Okay, so smart move by the prosecutor. That was good on him to do that, to try to take the sting out ahead of time and try to anticipate what's coming. Jesse, want to get your thoughts on what he said, please.
Dr. Gullidge is the pathologist and the medical examiner for the state. And perhaps he's done this several times, and he's also very familiar on sometimes what a jury is listening for. And so he's done some of the state's work for them. He's boosted himself. He has not only distinguished himself as someone having a hands-on approach to the analysis and his final outcome and to his conclusions, but he's also sort of downgraded what the defense expert is planning to do, that the defense expert did not have this hands-on approach.
Right.
So he sort of boosted the state's case because this case is so circumstantial.
It is, it is. Jesse Law, Holly Waltman, so great to have you with us today. When we come back, folks, we're going to continue in our verdict watch in Florida versus Nelson. Will the jury decide his fate today? They could. The clock is ticking, 11 hours, 43 minutes and counting. They're deliberating through lunch. Also, we're going to be back with more live coverage for you of Georgia versus Terrell when we come back. Thank you so much for being with us here on CourtTV Live. I'm Julie Grant. I'm your midday host. Wow, is it a busy day here as we cover two trials for you. We are in a verdict watch in the penalty phase of Florida versus Scott Nelson. The court sequestered the jury. They began their deliberations yesterday afternoon. And remember, Nelson could receive the death penalty for murdering Jennifer Lynn Fulford. The jury asked a question this morning. They want to hear testimony again, read back to them by the court reporter from two different mental health experts. Specifically, they're asking to hear where the experts talked about bipolar or PTSD. Those are the words they want to hear again. And what's happening now is the attorneys are trying to come to an agreement. The defense only wants a small portion of it read back. The prosecution wants a larger portion. The judge is saying those words, bipolar and PTSD, were just ubiquitous throughout all the testimony, meaning they're everywhere, and so why not let it all come in? And that may be what the court is inclined to do. So they're going to be on a lunch break. The jury's still deliberating as they're eating their lunch. We've got our crew there watching things for you. As soon as we hear anything, we'll take you there live. Also, we're covering that heartbreaking case out of Georgia. 91-year-old Adam Bennett was allegedly beaten to death by the person who was supposed to be caring for him at the assisted living facility where he was. Landon Terrell was working as an unlicensed caregiver there where Bennett was a resident, and he was responsible for caring for him the night of August 14th till August 15th. Now, Terrell's being accused of felony murder, with the underlying crimes being elder abuse and elder neglect. The state rested its case, but also in the case, we saw that Landon Terrell made consistent statements to law enforcement that he never hit Adam Bennett. He was trying to change his diaper, and that the man fell, and that he had a history of falling, and that this was all an accident and he didn't strike him. So now tomorrow the defense is going to call their first witness. They're choosing to put on a case, and of course Landon Terrell could still choose to testify. Now, we know that one witness they are definitely calling is their own forensic pathologist. A battle of the experts is what's going to happen, folks. So what we want to do right now is take a listen back to some of the testimony from the medical examiner the state put on the witness stand, who performed the actual autopsy on Adam Bennett.
What are those exhibits?
These are my autopsy photographs.
And are they fair and accurate depictions of the autopsy that you performed on, I believe you said, August 18th of 2017?
They are.
Judge, I'm going to tender an evidence states exhibit 37 through 47.
No, Judge.
I'll be admitted.
Did you determine Mr. Bennett's age as part of your examination?
I was told his date of birth, and we calculated his age.
So, how old was he?
91.
Okay, thank you. Okay. So I'm going to, what I want to ask you to do is I'm going to start working through. I want to ask you to explain the autopsy process that you went through, particularly with Mr. Bennett, and I'm going to show some of the photos, and they're going to show on the screen. So there will be actual autopsy photos that will appear, and I say that as much, Judge, for I understand that there might be folks watching. If they don't want to see these, then now would be the time.
Okay.
So we're going to start with State's Exhibit 37, and we'll work our way down from the head down. Does that sound like a... You've got them in front of you. So you keep them in front of you, and if you need to step down, if you feel like more comfortable in front of the jury, we can do that. But we'll start with this method. When the body comes in, tell the jury a little bit about the autopsy that you performed, the examination you performed of Mr. Bennett. What are your first observations?
Absolutely. So just so that you understand our process, we do take a lot of documentary photographs. Some of them are not particularly useful in showing anything in specific. Some of them are. But we will always take photographs of the decedent with our case number. We assign each individual who comes into the medical examiner's office a unique case number. Sometimes we don't know what their name is, so we only have a case number to work with. We will then always photograph their face with our case number to associate the decedent and the case number. So in this case, what you are seeing is our identification photograph of Mr. Bennett, somewhat out of focus, unfortunately, associating him to the case number 17C962. Because our photograph for associating with our case number is of the face, sometimes you are able to see the presence of injuries that may be there. Anytime we try and show injuries, we like to show the injuries close up with a scale, with a ruler, something to show you how big it is, because with photographs it can be deceiving how large something is. But we also like to show it far enough back that you can see where it is on the body. So in this case, even though you can see that there are contusions over the left side of his face, we're going to take a look at those a little bit better with a ruler so that we can see them close up.
I'm going to interrupt you briefly. You mentioned a word, contusion. What does that mean?
Contusion is the medical term for a bruise. We're going to use a couple of terms repeatedly. One is abrasion, and an abrasion is a medical term for a scrape. And a contusion is the medical term for a bruise.
Dr. Gology, and you mentioned the contusion on the left side of the face. Is there anything significant on the forehead?
I think the thing on his forehead is actually just a little skin lesion, a seborrheic keratosis, something that doesn't appear to be tremendously important.
Can I see this photo?
Sure.
So I'm going to show them. It might be a little better focus here. If you had noted or had noticed that the thing on the forehead was trauma or an injury, is that something that you would make note of in a report?
Absolutely.
And again, you're doing your examination yourself and then taking photos. I assume, are you taking notes as you're doing that?
Absolutely.
Okay. All right, I'm going to move to the next photo, 38.
So photograph 38 and in a moment 39 are just quite literally giving you a view of Mr. Bennett as we opened the body bag to show you how he arrived with his medical therapy in place. So if there's any questions later as to what medical therapy may have been there, we're able to go back and show this is exactly what he looked like before anything was removed from our office. And so in this particular photograph, you can see the chest tube that's been placed in his left chest. You can see the IVs present on his left arm. You can see some of the medical devices.
All right, folks, we have to fit in a quick break right now. When we come back, we'll continue our coverage of the state of Florida versus Scott Nelson and that verdict watch, 11 hours, 55 minutes and counting. This jury is out. Also, we'll have more on the case of Georgia versus Landon Terrell and a live report for you coming up as well after this.
Tonight on Court TV.
We're on verdict watch in the nanny abduction and murder trial. We'll bring you live updates as to the jury deliberates on whether convicted murderer Scott Nelson will receive the death penalty. Our crews are also live in the courtroom for Georgia versus Terrell, a nursing home caretaker who prosecutors claim beat a 91-year-old resident to death.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
We are so grateful for your company here on Court TV Live. Welcome back. I'm Julie Grant. We are bringing you live gavel-to-gavel coverage of two different courtrooms. One of them is in Orange County, Florida, where we've been for a while. Now we're in a verdict watch. This is the case of Florida versus Scott Nelson. The clock is ticking right now on the corner of your screen. The jury deliberation clock is nearing the 12-hour mark. This sequestered jury is tasked with deciding whether to recommend a sentence of life in prison without parole or penalty of death. Now, Scott Nelson has already been convicted of murder by this same jury. That happened in the guilt phase of this trial. The victim in this case is beloved nanny Jennifer Lynn Fulford. The jury began their deliberations yesterday afternoon, shortly after 1 o'clock. As soon as there is a verdict in this case, we will bring you into the courtroom live. Also, in a Metro Atlanta courtroom, we are covering a heartbreaking trial. Landon Terrell is on trial for allegedly murdering a 91-year-old man. Terrell was working as a caregiver in the assisted living facility where Adam Bennett was a resident. Now, court is in recess for the afternoon in that case, and what we want to do is catch you up on some of what we were unable to show you live because we were live in the Nelson trial with those closing arguments. So yesterday, the state presented their medical examiner, the person to give that expert opinion that the cause of death was blunt force trauma by assault and that the manner of death was homicide. Let's watch back his testimony now.
And I think we'll come back to it as we're moving towards the chest, but I want to take this opportunity. So when you're putting the tube in, is that going to cause trauma?
Absolutely.
What sort of trauma will that cause?
Well, you have to put the tube in, first thing you have to do is make an incision. So they have to actually take a scalpel and cut through the skin. And then you actually have to take that tube and the best blunt dissection tool is your finger. You take your finger and work a hole to get the tube in, and then you push the tube into place and get it seated, and then hook it up to suction to start draining out whatever's in there.
Do you break ribs to put the tube in?
No. You shouldn't. The ribs are, because of the way that dissection is done and the location of the vasculature, you actually make an incision right over a rib and you take your finger and push through. Your fingers shouldn't break ribs in the process. Once you put the tube in place, you're sliding it over the rib. You can sometimes cause some injury inside the chest. Sometimes you can make a small laceration of the lung, but at the point you're putting a chest tube in, making a small laceration of the lung is probably not the person's biggest issue.
And I guess in your autopsy of Mr. Bennett, did you make any determinations that he had some chest injuries?
He did have chest injuries.
Okay. To what extent can you say whether or not they were caused by the chest tube?
I don't believe that the blunt injuries that I saw were related to chest tube placement.
And we'll come back to that once we get to the chest. So this is, at this stage, we've got 38 and 39, I guess from head to toe. What are the areas of the body where you observed trauma for Mr. Bennett?
The places that I thought were most significant was the head, the chest, and the abdomen.
Okay. And then after the external examination, well, actually, we'll move to State's Exhibit 40. And of course, you mentioned that you would use some measuring instruments. Is that what we are seeing in State's Exhibit 40?
That is.
Okay. And
it's a ruler with our case number on it, and using it to depict the actual size of injuries.
What's the significance of the size and color of the contusions that you're observing?
So, with respect to any contusion, they heal. And in the process of healing, some people will describe that there is a particular color pattern. Everybody doesn't have the same color pattern. Some people say it has to go from blue to purple to green to yellow to, it skips. Some people don't go green, some people don't go yellow, some people don't go purple. But the important thing is to recognize that as a bruise heals, and they do heal, they do change color. And the edges do become blurry as opposed to nice and sharp. We've all seen that. We've all had bruises that as we watch them heal, they start to fade at the edges. Sometimes they even spread before they fade. They then start to change color and the edges start to change color and they slowly go away. So when we look at any contusion, part of what we're doing besides describing the size and the color is looking to see whether it appears to be a healing contusion versus being a acute, a fresh contusion.
And in your investigation, was there any indication that the bruising may have occurred a few days prior to you observing the body?
Yes.
Okay. Is the bruising that you've seen consistent with any particular time frame?
This bruising is very consistent with several days of healing.
What else can you tell us about the bruising that's observed on Mr. Bennett's face?
We're going to see it over a few photographs because it's not easily captured in a single photograph.
And I'll do this, Dr. Gullidge. You've got a series in front of you, so given that question, if you'll tell me, I will switch to photographs.
Okay.
And will you describe the bruising in your observations to the
So
jury?
we've seen 40, so if you would, could you move to 41, please? Because I think that will show some of what we need to see, and then we'll go from there.
Yes, sir.
So in 41, what we're looking at is just a little bit of his face turned. And what we're going to see is a couple of important details here to me. One, we do see healing. You can see where some of the bruises are fading around the edges. There are even little areas where Maybe that purplish discoloration is sort of turning the slightest tinge of green. But these are very recent bruises that have begun the healing process. But the other thing I want you to notice is that we see injuries present to the front of the face, but we also see them to the side of the face. And as you look here, and we're going to see in just a moment, we're also going to see them down on the neck. And so we're seeing multiple surfaces. Our heads are not flat. And so when I see an injury in one particular location, it's very easy for me to explain why somebody might have an injury in one particular location. If there's an injury on the nose, you could have it because you fell down, and the nose is one of the first things that hits. If you have an injury on the forehead, you could easily have a fall and strike your forehead. If you have this and this and this, I've got 3 locations that match up nicely of high planes where it would be easy to explain a single injury causing all 3. With this, we're going to see these injuries on the front of the face, the side of the face, the underside of the neck, the side of the neck. Well, these aren't a single plane. This is a single location, but there are multiple. This shape is difficult to have a single impact explain injuries all the way around. So if you would, could you move then to 42, please?
Yes, sir.
So as you can see in 42, we're looking at the left side of the neck. And again, the most midline anterior, the most midline front portion of his neck, you can see that bruise is starting to fade just a little bit. But then, if you'll move please to 43, as we look down on the side of the neck, sort of underneath the chin, there's a large contusion down there that has sort of spread around sort of the side of his neck.
All right, now I want to bring in our special guest in the studio to help me discuss this, criminal defense attorney Holly Waltman and former criminal defense attorney Jesse Law, also a current mediator. So thank you, ladies, for staying with us and watching that important testimony from the medical examiner. I want you to put on your criminal defense hats. He was talking about how these injuries, he noted, were on different planes of the body. And essentially the sum of that is that they are likely not caused by one incident, this incident in question. How would you cross-examine him, Jesse?
Well, basically, we would have to examine him in terms of the length of time of those bruises, the length of age of those bruises, the sources and the possible causations of those bruises, and to mitigate the factor that it may not have come from the defendant, but it may have been caused by other factors such as falls or, at that point, the defense is going to go on a saga of trying to have the particular examiner speculate as to what could lead to all these possible contusions. And that's going to give the jury a whole plethora of reasons as well as to target what else could have caused these contusions, what else could have caused these bruises, other than possibly being assaulted by Mr. Terrell.
Holly, how would you cross him?
So Dr. Gullidge said something very interesting. He said everybody's different and not everyone bruises the same way, and they don't go through the spectrum of colors of bruises or healing bruises the same way. So I would definitely hit on that. And then he also said, I wrote down a couple words. He said these looked very recent. Well, I would try to nail him down. What does very recent mean? Is that today? Is that yesterday? And I would try to get his scope of testimony down to something so narrow that when I bring my expert witness to come and or when I bring my expert witness and talk to him about the things, I would try and negate some of the things that I nailed the state's witness down on.
Right. And we know that in the timeline, and of course we did a lot of research here at CourtTV for this case in preparation, we know that he fell on June 28th, he fell again on June 30th, on July 1st, July 2nd, he was found in his bed with a bruise on his left eye. He reported that he fell during the night, had fallen and hit his head, possibly. That was according to his daughter, who we saw that tearful, heartbreaking testimony from. So this is a guy then, fast forward to August 9th, also found on the bathroom floor. The daughter told police that he fell using his walker to get to the bathroom. So I would think if I'm on the defense side, you know, I'm going to really try to hone in on what you ladies were saying about the possibility there were all these other events that could have occurred outside of that window, the August 14th to August 15th window that the prosecution is honing in on, saying that there was a crime here. Do you agree, Jesse?
Totally. The prosecution has the burden to prove beyond a reasonable doubt that Mr. Terrell assaulted and battered Mr. Bennett to the point of his, and those bruises caused his death. Now, what the defense is going to introduce, and based also on Dr. Gutledge's testimony, is that there are going to be a whole host of other reasons. And as you've just gone through the timeline, and given his age and his frailty, and the fact that he's also unfortunately suffering from dementia, all these factors are going to go into the jury's deliberations to even determine whether they've met their burden or not.
Right. Holly, if you were the defense tomorrow when they go to begin their case, would you start maybe by going backwards and going to June when these falls have been documented, go through July, and then lead up to the event in question?
Certainly, Julie. And what's important to note here are these are the events that were notated in this man's file. These are the ones that they were reported. And not that nursing home neglect or abuse is anything to joke about, but some of these incidents don't make it to a patient's file. Some of these people are taking care of multiple patients at the same time and just possibly doing the best they can with the time and the energy they have.
You ladies are right. I mean, these are instances, I know we don't hear a lot about them, and you're both attorneys and being active in practice over the years. I mean, we hear of instances like this. I was just sharing with one of my colleagues that a doctor I know who had been watching our coverage shared with me that one of his office staff was attacked by someone at a nursing home, a dementia patient who didn't know what she was doing and thought maybe the caregiver was coming, you know, toward her to, you know, possibly harm her, and she was scratched and whatnot. So things like this do happen, and I know trials are for the truth. So it seems to me like what's really happened during the prosecution's case is that a lot of facts have come out that are very favorable and enlightening for the defense. Do you agree, Holly?
I do agree, and I think that this is a delicate situation for the Cobb County District Attorney's Office, right? They are trying to help and put forth the Bennett family's story. And that's the greatest thing about this system is that we do that with 12 people that don't have legal minds, that don't have legal background, and we are all seeking the truth. And so I do think that the DA's office is doing this for the family and for Mr. Bennett, and what ultimately will happen is going to be up to 12 citizens of the metro Atlanta area.
Yes, absolutely, Holly. I couldn't have said it better myself. Holly Waltman, Jesse Law, it is so great having you ladies here, and you're going to stay with us during our next hour. We just need to fit in a quick break here. When we come back, more live coverage for you of Florida versus Scott Nelson. We're over the 12-hour mark, my friends. We're 12 hours, 14 minutes of deliberations. Will the jury come back with a recommendation today? Also, we're covering Georgia versus Landon Terrell. This one is a heartbreaker. We've seen tearful testimony already, and the defense is getting ready to start up their case. Don't go away. Welcome back to Court TV Live, and a good Thursday afternoon to you. I'm Julie Grant. Thank you for being with us. We continue our gavel-to-gavel coverage of two huge trials for you today. First, Scott Nelson's fate is hanging in the balance at this very moment. The jury has now been deliberating whether he will receive the death penalty for 12 hours and 19 minutes. Got the clock running for you at the bottom of your screen. Also, one thing to remember here, before the court went on a recess, the attorneys were still trying to hash out whether the jury would hear read-back testimony from both of the experts in its entirety or just portions of it. So we're still waiting on a decision on that. The judge had asked both sides to get together and talk about it. So as soon as we hear something, we're going to take you there live. Also, the other huge case we're following, this is a heartbreaker. This one in Georgia. Landon Terrell is on trial for allegedly murdering a 91-year-old man. The prosecution says he beat Adam Bennett to death at the assisted living facility where Bennett was a resident. Now, Terrell was working there as a caregiver, and the state rested its case this morning. The defense is expected to call witnesses tomorrow. We know that they're going to be calling a medical examiner or a forensic pathologist to talk about how the alleged victim died. Yesterday, the prosecution called 8 different witnesses in its case against Terrell. And while the jury is on a break right now, we want to take a look back together at what happened in that Georgia courtroom on day number 2 of this trial.
He was nonverbal, but his eyes was open. He can move his arms, move his legs, but he just wasn't talking at all.
When you assess the list of his face on the assessments, it was assessed with no abnormalities, but today you're testifying though that he had a bruise on his lip, correct?
Yes, that should be in
the written narrative of
the written narrative.
Would you tell the jury what was the cause of death?
Blunt force trauma due to an assault.
Okay. And what was the manner?
Homicide.
What areas did he say he was having pain in?
The left side of the mouth,
Okay.
which was also swollen,
Okay.
and the chest and the side, the left side.
Who would have been responsible for the care of Adam Bennett, both in that evening shift and then in the shift that you arrived on?
The night shift we had, I believe it was Landon Terrell, so he would be in charge of the men.
You heard reference to this fall a week prior. You found him in the room on, I guess, on the floor?
Yes.
And he was laughing and joking about it.
Right.
You never heard Mr. Bennett cry out or scream out in any sort of pain or agony?
No.
Never heard any yelling or screaming?
No.
Did he express any sort of frustration or emotions about it?
I would say he was agitated
Okay. Why would you say that?
because the way he described Mr. Bennett and his interactions with him, the fact that he was really difficult for him to work with.
And I will see you lift him up. That's when you turn and hit his chest. All right. Was everything here when that happened? Right here? Yeah. Is that there? Yes. Was the nightstand there? Yes. Everything's right there. Okay. So where was his head in regards to the nightstand? His head was not that far from here.
He said that he was in pain. Mr. Bennett was telling him he was in pain. And then we asked him again about what happened, and Mr. Terrell said that Mr. Bennett told him, "You hit me," and that he was in pain.
We were able to see the outside injuries, but what was more telling was what was on the inside, and that's where we found out he had multiple broken ribs, not just on the front, but on the back side of his ribs as well. 3 were broken. He said that could only have been possible with different blows on multiple different surfaces, not just one hit or one fall. And then he said also there was blood around the kidney. That was also an internal wound that had to only been caused with a deep hit, like a fist or an elbow or a knee would have caused that kind of damage.
Just a heartbreaking case. That was what we all saw on day number 2. And on day number 1, of course, Adam Bennett's daughter testified, the first witness that the state called. Very tearful testimony, and she received some voicemails from her dad that night in question saying he was dying and hurry, hurry, just so hard to listen to. Such a heartbreaking case. And again, the defense is prepping right now likely to get ready to put forth their defense by choice tomorrow. The jury's on a break, and of course we're going to continue our gavel-to-gavel coverage. We'll also have a live report coming up on this case to get us all caught up. Shanley Painter is standing by in Georgia for us, and Julia Janae is standing by with a live report for us also in Florida. We're in the penalty phase, folks, of Florida versus Scott Nelson, the man convicted of the brutal murder of nanny Jennifer Fulford. Clock is ticking, 12 hours, 24 minutes and counting. We'll continue our live gavel-to-gavel coverage for you right after this.
Tonight on Court TV.
We're on Verdict Watch in the nanny abduction and murder trial. We'll bring you live updates as the jury deliberates on whether convicted murderer Scott Nelson will receive the death penalty. Our crews are also live in the courtroom for Georgia versus Terrell, a nursing home caretaker who prosecutors claim beat a 91-year-old resident to death.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
This is Court TV Live, your front row seat to justice. I'm Julie Grant, and we're so glad you're with us on this Thursday afternoon. We continue our gavel-to-gavel coverage on 2 huge trials happening right now. We've got the Verdict Watch happening in Florida, the death penalty case. Florida versus Scott Nelson. The jury sequestered, began deliberations yesterday afternoon. He could get the death penalty for the brutal killing of Jennifer Lynn Fulford, that beloved mother and nanny in the Winter Park area. Got the clock ticking. They're continuing their deliberations through the lunch hour. And we're also at the same time following a heartbreaking case out of Georgia. 91-year-old Adam Bennett, this man right here, was allegedly beaten to death by the person who was supposed to be caring for him at the assisted living facility where he was staying. Now, Landon Terrell is being accused of felony murder in this case. The underlying crimes, the prosecution says, are elder abuse and elder neglect. The state has rested its case, and what we want to do now is take you live outside of that Metro Atlanta courthouse where we find Court TV's legal correspondent, Chanley Painter, standing by. Chanley, good afternoon to you.
Good afternoon, Julie. Yes, the state rested its case this morning, and we will not have trial again until tomorrow because the defense's first witness is an expert traveling in today from out of state. He will be testifying about his own findings. He will examine the pictures of Mr. Bennett, the injuries to Mr. Bennett, and determine what he thinks happened in those last days of his life. He also is an expert that is able to testify about the credibility of the investigation, according to the defense attorney. We found this out in pretrial motions. So we might hear testimony from this expert about how the detectives and the investigators missed some things or misinterpreted what was at the crime scene, Julie.
I want to pick your brain about exactly that, please, Chanley. We know through all the research our wonderful Court TV team did on this case that one of the officers wrote in the arrest warrant that Landon Terrell did admit to striking Adam Bennett in the torso, an admission which you know is something huge in the legal world and can be used against the accused in a trial. And we were watching for that, all of us. I know you were too, watching to see where's that admission in the state's case, and it never came. What can you tell us about that, please?
Yes, we were sitting in the courtroom keeping, our eye out for that piece of evidence, and we thought maybe we would hear it this morning on the final taped interview that the state was going to present to the jury, and we did not hear that. And you're correct. When he was arrested back in August of 2017, the warrant did say that he admitted to striking the 91-year-old, and we've not heard that in evidence. And back in 2017, of course, all of the media picked up on that statement, and it was all over in news coverage. And now at the trial, there's no evidence to back that up. Well, I ran into the detective after he left the witness stand, and I wanted to ask about, why didn't I hear that, or did we miss that somehow? And he said, no, when we were listening to the audio this morning in court, right at the beginning when Landon Terrell tells the detectives that he's describing what happened again, that he fell from the bed and put him back on the bed, he said he hit him in the chest during that. And the detective said that he interpreted I hit him in the chest as the strike or the punch, and that's what he used as the basis in that arrest warrant, Julie.
Oh, Chanley, that is quite a mistake to make, to interpret something and then say hitting someone in the chest versus did admit to striking. I mean, admitting to striking just sounds so violent. It sounds like an attack versus I tried to catch him when he was falling and I bumped him and my body kind of hit his as we were, trying to save him from hitting the floor. I mean, wow. If I'm the defense team, I'm going to make a big deal about this. Did they?
Well, on cross-examination, his attorney was very tedious, going step by step through each of the audio recordings, showing the jury what Landon Terrell was consistent on, and that was that he never struck Adam Bennett. And if we think back through the opening statements and the evidence, we've not heard any evidence that he did strike or hit or punch. Now, the medical examiner seems to think that the injuries had to have been caused by some sort of blunt force trauma from a hand or a fist, but that's really all that we have to support that. In the cross-examination this morning, the defense attorney made it clear that he was consistent, cooperative with law enforcement back in 2017, and he has the same story still today, Julie.
Right. And I think something interesting to remember is we know this because of our research, and our wonderful Court TV viewers know this because of what we're sharing with them, but the jury wouldn't know this unless it was presented, and it wasn't.
You're right. So they don't know. This is the first time they're hearing all these details about the case. They don't know what's in the court file or the pretrial motions or anything that's outside of the presence of the jury. What they know based now on evidence is that Landon Terrell did tell authorities that he failed to render care as he was supposed to when Mr. Bennett was complaining of pain throughout the night. He says that that's, quote, what he's guilty of is not doing that. But again, no evidence of striking or punching or hitting. It was an accident, according to Terrell. And so it'll be up to the jury to decide whether or not they believe him.
Right. Jenny, one last question for you, please, before we let you go. Which witness in this trial so far has seemed to affect the jury the most, in your opinion?
Oh, that has to be the first witness, the daughter of the victim, Christine Houck, who took the stand. It was very profoundly emotional, Julie. She was tearful throughout most of the examination. And when she described those last moments and days of her father's death, you could see it affecting the jury for sure. They even had to dab their eyes. You could hear audible sobs throughout the gallery. She really painted a picture of who her father was. In fact, the literal picture is still on the witness stand days later after she testifies as a constant reminder for the jury of what's really at issue here.
It was so hard to watch her testimony. Janley Painter, so great to have you reporting. Thank you so much. Now what we want to do is turn our attention to the other huge trial we are covering here for you on Court TV Live, Florida versus Scott Nelson. We're in the penalty phase. The jury could come back at any moment recommending the sentence for him, and it could be a sentence of death. We want to take you now live to Orlando, Florida, where we find Court TV crime and justice reporter Julia Janae standing by for an update. Julia, good afternoon.
Good afternoon, Julie. You're right, we are in a bit of a recess for court. Judge Keith White is on the bench for other matters right now, and he's asked the attorneys on both sides to come back around 2:30 to see if they have agreed on what they are going to tell the jury about the last question. The last question this jury had is that they wanted a readback of 2 psychologists that testified this week. They want to know everything those 2 witnesses said about the words bipolar disorder and PTSD. But the issue is, how much of the testimony do you tell these jurors? And that's what the attorneys have spent the last couple of hours trying to agree on. Do you just tell them the question and answer, or do you tell them the questions before the entire page of that word? So we have yet to see. We'll know in the next 20 minutes if these attorneys were able to reach a decision.
Julia, I'm sure you picked up on this being an attorney yourself when the judge seemed to allude to saying, look, why not just let all of it back in? He said it seemed to him that based on his recollection that the terms are ubiquitous, and why not let them hear everything? Can you tell us how much time might that take if the judge makes that decision to hear the testimony from both of these experts read back in its entirety?
Well, just looking at the time that these witnesses stayed on the stand, first Dr. Valerie McLean for the defense, she lasted the entirety of the morning. So it was about 3.5 hours that she was on the stand. And then Gregory Pritchard actually spanned 2 days, a couple of hours on one day, and then it went into the next day with cross-examination. So the judge will be able to, if they can't reach a decision, that's what he'll say, and that's what some judges do recommend, is that the entirety of testimony be read back and not bits and pieces. But it's important to point out that both sides have a different number of pages that they want read back. The defense picked out 50 pages worth of testimony that they say include the words that were asked in that note. So that would be, we estimate, about a minute a page, so 50 minutes of testimony that would be read back by the court reporter. The state, on the other hand, wants a lot more to be read back. They want 300 pages to be read back to this jury. That could take up to 5 hours, not including breaks that this jury might take, that the court reporter might need to read that much information back all at once, Julie.
This is really interesting which way this may go, Julia. If we do see that read back in its entirety, it may affect the planning. It's my understanding this jury is planned to be with this case until about Friday, but being that it's Thursday now, that could likely change, right?
this really might create an issue for the court because they are only qualified through the 12th of July. Jury selection started back on June 10th, so this has been a month that these jurors have been coming to the courthouse, and you give them a time period of how much this could take so that they can let their employers know, their families, any arrangements that they have to make. But tomorrow is that deadline, so we have yet to see what this court will decide on how to handle that if it goes past the end of the day on Friday. We don't know how late they can deliberate. We know last night we went to 9 o'clock at night and the judge hadn't told them to stop. They actually asked to stop. They said that they were tired. So whether it could go well into the night on Friday is yet to be seen, but their time as jurors does expire tomorrow, July 12th.
This is really getting interesting, Julia. Talk to me about last night. Walk us back. They had an interesting question last night, what they wanted to see. Would you tell us about that, please?
Yes, last night they kind of gave us an indication of what they would want today. They wanted what they call the DSM-5. It's a diagnostic manual that therapists, psychologists, psychiatrists use to define mental health disorders. And it's a book, a very thick book, that the defense attorney Chelsea Simmons used in her cross-examination of Dr. Greg Pritchard. He was the state's psychologist that they used as an expert. So there was a lot of reading from this book. The expert looked at it while he was giving his testimony. The attorney looked at it, but it wasn't entered into evidence. It was just used as a reference. These jurors are very astute. They've asked before for things that they saw in court, but that they didn't get back in the jury room. So it gave us an indication that they're looking at these mitigating factors. They want to know more about the mental health disorders, but the judge said no, because that is not evidence. You cannot get that manual. So what we learned today is that now they want the testimony from those psychologists. If they can't get the book to look it up, it sounds like they would rather hear it from the horse's mouth, Julie.
Certainly. They're taking their job very seriously. What more can you ask for in terms of a jury? And this judge is being so thorough. We've definitely seen that. How about Scott Nelson? How have you observed him being over the last 2 days?
He is still very involved in his case. He wants to be there every step of the way. Today, he even asked the judge if he could be in the courtroom during this downtime we've had where these attorneys are going back and forth over the minutia of what parts of the testimony is going to be read back. He wanted to be there for that. He asked the judge if he could have the accommodations to stay there, because of course there's a certain number of deputies that have to be there if he's in the courtroom. And during lunch, he wasn't able to be there because they had those other proceedings that are happening in that courtroom, but the judge has tried to accommodate him as much as possible. He's pretty subdued compared to other days when we see him being a little bit more combative, talking to the judge out of turn. We haven't seen that over the past 2 days. He's been very compliant with his attorneys, doing what they say, nodding and really letting them take the lead as we can say a client normally would do, but that has not been the case during the beginning of this trial. So it is a change that we're seeing in Scott Nelson.
You are absolutely right, Julia. Nothing has been normal about this defendant, and our hearts break for the Fulford family. Julia Janae, Court TV crime and justice reporter, great to talk with you. We'll let you get back into the courthouse. When we come back, we will continue our live coverage of both of these trials. We're in that verdict watch in the penalty phase of Florida versus Nelson, and the attorneys are going to be reconvening in the courtroom in just moments from now. Also, we'll continue our coverage of the case in Georgia versus Landon Terrell, that worker at the assisted living facility. Did he murder that patient? Was it an accident? Is that how he died? Stay with us. More coverage for you after this. We are so glad to have you with us here on Court TV Live. I'm Julie Grant. We continue our gavel-to-gavel coverage of two compelling trials today. First, we're on a verdict watch in the case of Florida versus Scott Nelson. This guy's life is in the hands of the men and women on that jury. They've been out for 12 hours and 46 minutes and counting. We expect the attorneys to convene in the courtroom at 2:30 to discuss what testimony the jury will hear back from those mental health experts. So as his life is literally on the line, we continue watching this case. We're covering another heartbreaking case. This one in a metro Atlanta courtroom. This man, Landon Terrell, is on trial being accused of felony murder for the death of a 91-year-old man named Adam Bennett. Terrell allegedly beat Bennett, when he was a care worker at the assisted living facility where Bennett was staying. But the defense is choosing to put on a case. They're in prep mode right now, and they'll begin their case tomorrow by choice. They say that this was all an accident, all a misunderstanding, and that Bennett fell. And that's how he sustained the injuries as Landon Terrell was trying to catch him while he was doing a diaper change. We know that Terrell has been consistent in his statements to investigators with the same story about changing him and that him falling, and also with him being combative with him. What we want to do now is take a look back at perhaps some of the most vital testimony to the state's case, and that is the testimony from the medical expert who says this is a case of blunt force trauma, a death and an assault, a homicide case. Let's watch.
From the head moving down, is the chest the next area where we observe?
It is.
Okay. And is that what we're looking at? Is that begin to move down in Exhibit 44?
It is.
So in 44, does it look like some of the apparatus that we previously saw, did you remove those?
We did. At that point, what we did during the autopsy is we removed all of the medical therapy. Actually, you can see the reason that you see a clamp in that particular photograph is that we left the chest tube in place, simply cut it to take the photographs so that as we actually did the examination, we were able to look at where that chest tube was placed. So what we're seeing here is, again, a series of photographs taken to depict what Mr. Bennett looked like cleaned up after all of the medical therapy has been removed, to show maybe a little bit clearer picture of what he looked like.
And can you describe the injuries to the chest that you observed?
They will be better described on a subsequent photograph if we can get there. This, I think, is just a much better at showing sort of what he looked like, and then let's look at the injury photograph to describe them.
Is that 40? Tell me which number.
That's 46.
Yes, sir. So 46, is this the torso?
This is the torso, abdomen, even the top edge of the hip.
Can you describe to the jury, when you performed your autopsy, what were the injuries that you observed to Mr. Bennett's torso?
So from the outside, what we see is a very dramatic contusion spread from the top of his torso sort of all the way down to his hip area. Within that, you can see some areas where the skin has torn. Those are skin tears, and his skin, because of his age, is very fragile. Those skin tears are very, very recent. They don't match to the age of the injury, and honestly, they were probably done just manipulation, when we removed the tape that was holding that chest tube in place, a lot of that happened. So those are not going to be described as injuries because they weren't part of the injury that caused his death. They're actually just, like I said, they're from removing tape, and they're from moving him around. The large contusion that we're seeing is, again, a healing contusion. It has spread some. You can see the edges are starting to fade just a little bit, but it does extend most of the way down the side of his chest, all the way down his abdomen, even onto the top of his hip.
Are the healing patterns that you observed there consistent with the healing patterns that you observed in terms of timing for the face?
These are very consistent with each other, yes.
Okay. Did you actually go into the chest cavity itself?
Oh, yes.
Okay. Can you describe for the jury what you observed when you went into the chest cavity?
Absolutely. So there are injuries. What we're seeing here is the surface. Once we actually go into the chest and into the abdomen is where we saw the injuries that match to the outer injuries. And in this case, what was present was rib fractures of the left ribs, and there were actually 2 sets of rib fractures. There was a set of rib fractures on the lateral side, on his side, which fractured left ribs 6, 8, and 9. And then there were fractures more towards his back, which were actually ribs 6, 7, 8, and 9. So the similar ribs, rib number 7 was only fractured once, but ribs 6, 8, and 9 were fractured in 2 separate places on 2 separate sides, the side and the back. Besides those fractures, there was remnants of fluid within the chest, but that's not uncommon. And there was a chest tube in place, and it was placed appropriately. The lungs, because of his hospital stay, I was not willing to say his lungs were bruised at the time. That's something that between healing and a hospitalization, looking at those lungs for the presence of bruising versus the presence of blood settling into them can be very difficult, especially with a prolonged hospitalization. And I'm only willing to document injuries that I feel very confident that are actually injuries. I try very hard not to speculate. So I did not describe specific injuries to his lungs simply because after several days and after he was on a ventilator and all of those stuff, his lungs had changed in appearance. But within his abdomen, on the left side, below the level of the ribs, a little bit further.
If you're just now joining our coverage, we're recapping some of the most important testimony presented by the state in the case of Georgia versus Landon Terrell. He's the worker at the assisted living facility being accused of felony murder. The state saying that he beat this patient, but he said all along that this was an accident and the patient was combative and fell. And that's how sustained the injuries. So we shall see what the defense presents tomorrow. In the meantime, we are waiting for everyone to reconvene in Orlando, Florida, in the death penalty case versus Scott Edward Nelson. The jury already convicting this man. Now they've been out for almost 13 hours in their deliberations on whether he should receive a sentence of death. We're going to take you live into the courtroom after this quick break.
Tonight on Court TV.
We're on Verdict Watch in the nanny abduction and murder trial. We'll bring you live updates as the jury deliberates on whether convicted murderer Scott Nelson will receive the death penalty. Our crews are also live in the courtroom for Georgia versus Terrell, a nursing home caretaker who prosecutors claim beat a 91-year-old resident to death.
Closing arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. We're so glad you're with us on this Thursday afternoon. Folks, we're doing gavel-to-gavel coverage of 2 criminal cases. We've got our eyes in Orlando, Florida. We're waiting for things to reconvene at any moment in that courtroom. This is the case against Scott Edward Nelson. He's already been convicted of the brutal murder of beloved nanny Jennifer Lynn Fulford. We're in the penalty phase now. The jury has been out for almost 13 hours. Got the clock ticking on the bottom of your screen. They worked through lunch, and they've asked to hear some testimony read back to them. So earlier today, we reported that the question to the court was they want to hear testimony in which the words bipolar and PTSD are used. And so during the lunch break, the judge is asking the attorneys to try to come to an agreement on whether they'll hear portions of it or all of it. So as soon as that starts up, we'll take you there live. Also, we've got our eyes in a Metro Atlanta courtroom. The case against Landon Terrell, the 35-year-old, is being accused of the murder of a 91-year-old dementia patient at the assisted living facility where he was working. It's the Sunrise Assisted Living Facility of East Cobb in Cobb County, Georgia. And this man is accused of severely beating this man here, this U.S. Air Force veteran. But the defendant says this was all an accident. This was a mistake, and that he was changing his diaper as he normally would, and the defendant began to fall, and that's where he hit him, and that's how he sustained the injuries. So the defense is choosing to put on a case. We imagine they're in prep mode right now as they're getting ready for tomorrow when they can begin calling their first witness. We know it's going to be a medical expert, and the question still remains whether Landon Terrell will testify. He told the court today no, but that, of course, could change. So we've got our eyes there for you. We've got our crew standing by giving us updates. In the meantime, what I want to do while we're waiting for things to start back up in Orlando, I want to bring in some wonderful guests we have today in the studio, criminal defense attorney Holly Waltman and civil attorney Jesse Law. Thank you both so much for being here. And Jesse, you also have criminal defense experience. You're a mediator as well. I want to tap your brains, ladies. Okay. Earlier, I know you were watching the reporting. My colleague Chanley Painter was talking about this discrepancy in the Terrell case where a detective said that he interpreted a hitting of the victim, and in his report wrote he did admit to striking Adam Bennett in the torso. We were watching for that to be brought out in the state's case. It never was. She caught up with him in an elevator and said, hey, you wrote that in the arrest warrant. You never said it on the stand. What gives? He said, well, it was just my interpretation of what happened. She said the defense team didn't really hone in on what was in the in the arrest warrant in that document. Would you have if you were the one doing that cross? Holly, I'll start with you.
Absolutely. I'm not sure how you don't address that. This is a sworn affidavit subject to perjury, and this is an officer that has a badge and has post certifications to put people under arrest and accuse them of crimes. This is huge, and if the defense put this witness, state witness, on their list, then perhaps they could call him in a rebuttal situation. So maybe we haven't heard everything that we are going to hear.
That's a great thought, Holly. They could call him. They could call him in their case and ask him just that question, couldn't they? Officer, this is what you put in your report. You didn't say it yesterday when you were on the stand. What gives? Jesse, would you do the same thing?
Actually, I would. During the course of the investigation, the officer was clearly looking for certain words and certain admissions from the defendant. And when he heard the word hit or something to the effect, you know, it's just semantics. But when filling out that arrest warrant, unfortunately, the officer used his own words rather than the words that he heard from the defendant. And that may leave a problem for the state.
Sure. Ladies, appreciate your thoughts. This is great. We want to switch gears as we're waiting. At any moment, things could pick back up in the Nelson case. So we know they were supposed to come back about 2:30. We're watching it there. Got a crew in the courtroom. We know that there are a couple things that could happen here. The judge could say, let's hear all of that testimony be read back. And you heard our reporter, Julia Janae, saying that it was about 3.5 hours for the defense expert, and then it spanned 2 days, albeit not 2 entire days, but several more hours for the state's rebuttal witness. Do you still have the same thoughts that all of this testimony needs to come back in? Holly.
In order to avoid what could be a mistrial, I do think that the judge will let all of it in. And one thing that I think is important to consider here is even though this case is happening in Florida, which is in the South, and traditionally southern states tend to be more conservative, I think it's important to note that a lot of people don't grow up in Florida and retire there. We have a lot of transient people that might be making up the jury pool. So I'm not exactly sure if it's up for debate whether or not Scott Nelson has any of these mental conditions. We all can agree, I think, that he is not a normal person, and I don't really see what kind of clarification this is going to do for that jury.
All right, Holly, Jesse, thank you. We understand court is resuming right now. Let's watch live.
Okay, so are these the court's copies, or is this what's going to be given to the court? Okay, we need to label this.
Dr. McLean first, then
Yeah.
Dr. Richardson.
Is there any objection to Madam Clerk just writing on the back, read back number 1, 7, 11, 19 for Dr. McLean, and then read back number 2, 7, 11, 19 on the back of Dr. Pritchard?
No objection.
Nelson?
None, Your Honor.
Okay, so the attorneys have reconvened in the courtroom, trying to understand if the jury is going to receive just portions of the testimony including the words PTSD and bipolar disorder, or if they just can't come to an agreement on the portions, in which case the court is likely to say that all of the testimony, just in an abundance of caution and because of the rule of completeness, it all should come in. So there's a little moment of silence here, but you can see Scott Nelson is seated there at the table with his attorneys. He requested earlier to be part of this process, requested lunch, and then requested to come back and be there in the courtroom for all of this. And we're talking about quite a bit of testimony. State's experts spanned 2 days, albeit not 2 full days, but still 2 days, quite a lengthy period of time. He was on the stand many hours. The defense expert for a shorter amount of time, about 3.5 hours. And the testimony would be read back by the court reporter.
The jury back in. I'm just using standard 4.4 and then number 1 where it's granted. So I will tell them, members of the jury, you have asked that the following testimony be read back to you. Dr. McLean and Dr. Pritchard, the court reporter will now read the testimony that you have requested. First, she will read Dr. McLean, then she will read Dr. Pritchard. Any objection to that?
No objection. No objection.
Mr. Nelson?
No, sir.
Deputies, could you please hand marked as readback number 1, 7/11/19, and marked as readback number 2, 7/11/19 to Madam Court Reporter. Thank you.
I know I'm reading the highlighted portions, but am I stating whether it was direct and then cross, or do I just read what's highlighted?
Yes, you say direct and cross, that is highlighted on the pertinent pages in the order in which it occurs. Did you want to take a look at it just so you're familiar with the format before she begins? Yeah.
Okay.
All right, we know that was a little bit hard to hear. It was hard for me to hear it too, and I confirmed this with our crime and justice reporter, Julia Janae, that the attorneys, when they were on the break, came to an agreement to admit just portions, to have the court reporter who you see there behind the sheriff's deputy read back portions of that testimony. We're not sure how long, though, so that's the question. So we know that it's not going to be the entire testimony. We just don't know how many pages. We know that earlier when they were arguing, the defense wanted about 50 pages only, the state wanted about 300. So we'll see if they've met somewhere in the middle. We know there's a moment of silence here, but at least we know this is going to be a shorter amount of readback from the court reporter.
I'll do that. We're going to take a brief recess.
Okay, so you heard the judge saying they're going to be in a brief recess. And just to, so we can understand, I was talking with Julia Janae as we were watching that, and I was messaging her, and she said that it doesn't look like it could be near the 300 pages that the state wants, just looking at the stack. She's in the courtroom and can see how high the stack of pages is. But while they get that together, what I want to do is bring in our wonderful guests to talk about this. We have criminal defense attorney Holly Waltman, civil attorney Jesse Law. So thank you for staying with us, watching that. Are you surprised they were able to come to an agreement on what comes in, Jesse?
Well, given the length of the testimony that was going to be given by both the experts, I think I saw Judge White give a huge sigh of relief, especially with the deadline coming up. So it's very, very fortunate that the attorneys were able to come to an agreement and to tailor a response that everyone hopes will be responsive to the jurors' question.
Sure.
And we hope that is sufficient to help the jurors proceed with their deliberations. because otherwise the jurors may come back with more questions.
Right. Good point. Good point, Jesse. Holly, your thoughts?
That's what I was about to say. If the testimony that the jury is wanting is not included in this, they'll write another question. They'll get to the bottom of it. They haven't come this far and given this much attention and time and effort to this case to have a question left unanswered. So I do think that it is a good step forward that both sides were able to agree. It will eliminate any wasted time and hopefully get the jury to the answers that they're looking for.
Sure. And as much as we want to be cautious, I think there is something to be said too in drowning them in more information than is necessary. If they're looking for something in particular, and they were very specific with these questions, knowing that we're talking about hours upon hours upon hours, we want them to hone in on what they do have the question about. So hopefully this is a great solution that both sides are in agreement upon, and the record's clear, they're agreeing, so we're not going to have an issue down the road. Okay, let's talk about this jury. Do you think, from a criminal defense standpoint, that this is encouraging? Would you be encouraged by this if you were Scott Nelson's counsel and your job is to spare his life? These questions that they're asking and what they want to hear back. Jesse?
I'm very glad the jurors are being very engaging and very proactive about wanting to get more information. It shows that they're engaged. It shows that they are very, very vitally interested in the makeup of this person, Scott Nelson, and what might have exactly motivated him to commit such a heinous crime, and whether the makeup of this particular gentleman warrants a death penalty. So they are doing that job, a job that they've been sworn to undertake, and I'm very glad that they're asking the questions that they are.
And we know that these experts said the opposite of one another when it comes to bipolar disorder and PTSD. The defense experts saying that he has these things, he suffers from them, and then whereas the state is saying, no, absolutely not. He's a narcissist with a personality disorder and has a little bit of depression as well. Holly, your thoughts, would you be encouraged by this?
Certainly. Every hour that ticks past is a win for the defense. And in the United States, there are states that don't even allow and don't have death penalty as an option for a sentence or a punishment. So I think that had there been consistency within the jury room deliberations, we would have had an answer one way or the other already. And so I do think that there is at least one holdout that is going to give hope to the defense team.
Let's talk about Scott Nelson, if we can, for a moment here, because what's so baffling here is he told everyone in the courtroom that he wants to be sentenced to death. He's saying that's what he wants. Don't know if his actions necessarily support what he's saying. We've seen a lot of very strange things from him, but we know he admitted to the crime in the interrogation. He acted proud to tell the jury and admit to the crime on the stand during the guilt phase, which was just truly disgusting. And then we get to the penalty phase here. Does this explain maybe why he wouldn't talk to the state about a plea negotiation, because he really wants death row? And does death row mean he really wants death? I mean, does he just know the system so well and think that I'm going to get much better treatment than I would in general pop if I get life in prison, so I better want to receive the death penalty and then hope I just live out the rest of my years doing appeals? Jesse?
Just the mere fact that he took the stand and told the jury that he wants death, and he goes into the details in such graphic detail. I mean, the first normal reaction would be he's nuts. And that would then lead to the next sequence of questions. Is he rational? Is he suffering from PTSD? Has he made these disclosures because of his mental health situation?
Right.
And I don't know, he may really be suffering from a mental health situation, or this may be a really good strategy to convince the jury that he didn't really have it all together up there.
Right. And Holly, just briefly want to get your final thoughts.
The current wait time for a death row inmate in Florida is 15 years. That number is going to get larger and longer. So is he a mastermind and able to do that? I'm not sure.
Okay. Holly, Jesse, thank you so much. We want to go back into the courtroom. Things are picking back up.